So hello students, welcome to Baji Rao IAS Academy previous year question paper analysis. So through these lectures we have been understanding the structuring and also the major themes which are being asked and repeated by the UPSC in the mains examination. So in today's discussion we will be understanding UPSC General Studies paper 2 that is being asked in 2022. Okay, so in this lecture we will be particularly dealing with Indian polity and the constitution section, right? So the first question that we are going to discuss here today is about the the growing importance of environment in the constitution. Now, how Supreme Court has been playing a key role in constitutionalizing the environmental aspects. So because of climate change and the global warming and the need to maintain the sustainability, the growing importance for the environmental protection and environmental conservation is particularly taken up by the Supreme Court. So in this respect, the question has been asking that the most significant achievement of modern law in India is the constitutionalization. So please remember this, constitutionalization of environmental problems by the Supreme Court. In this context, we need to discuss this statement with the help of relevant case laws. Now, while writing this answer, you must mention the relevant case laws. So what are those case laws through which the Supreme Court has tried to constitutionalize the environmental problems that we are facing currently? Now, firstly, you need to briefly write about the constitutionalization of environmental problems. Now, environmental constitutionalism is actually a recent phenomenon. This was not an old phenomenon, rather this is a new phenomenon. Okay, so it was recently gained prominence because of the environmental degradation and the need for more sustainable development, inclusive growth requirements. So because of all these reasons, environmental constitutionalism has developed as a recent phenomenon, particularly in the context of increasing the importance of environment in the Constitution of India. And environmental issues are directly and indirectly linked to the human rights of the people, international law and environmental law. So in the junction of these four issues, and constitutional law, human rights, international law and environmental law, the constitutionalized environmentalism has been gaining a lot of prominence. So therefore, it particularly inculcates recognition that environment is a proper subject for the protection in the constitutional text, and this protection is similar to the rights which are being granted to the human beings. Now, how we are granting the fundamental rights to the citizens in a similar way, constitutionalization of environmental problems also ensure that we are providing certain rights to environmental aspects. However, India is one of the major signatories of Stockholm Conference that took place in the year 1972. So in the year 1972, Stockholm Conference took place. So this conference, India is a major party to it, and this conference is also called as Magna Carta of environmental law. So in this context, since India is a major signatory of Stockholm Conference, India has started enshrining the environmental principles, environmental issues in the Indian Constitution itself. So this is being evident from the fact that the 42nd Constitutional Amendment Act, so that was brought in the year 1976, has brought two important amendments, or included two important articles in the Indian Constitution. So firstly, we need to talk about Article 48 of the Indian Constitution. Okay, so this is Article 48. So Article 48 says that protection and improvement of the environment and conservation of the natural heritage. And Article 48A, which is being part of the Part 4 of the Constitution, is part of Directive Principles of State Policy. However, when we talk about the fundamental duties, they are also part of part 4 of the Constitution. However, Article 51 subclause G has has amended, brought into the fundamental duties, right? So therefore it makes it mandatory on the part of the state as well as the citizens to protect and improve the environment. So this is how you need to give a brief introduction about the growing environmental constitutionalism in India, particularly in the backdrop of the Stockholm Conference. Now, the constitutionalism of environmental problems by the Supreme Court. Now, how Supreme Court has been taking up these environmental problems and trying to constitutionalize these environmental problems. Now, first and foremost, we need to discuss about Article 21 of the Constitution. Now, we all know that Article 21 is related to right to life and personal liberty. Right, this is about right to life and personal liberty of the individual. However, over a period of time, Article 21 is being further widened to include several environmental aspects. For example, protection of environment, and right to clean environment. So all these things are further included in Article 21 of the Constitution. Now, the broadening of Article 21 has started post Maneka Gandhi judgment. Now, we all know what exactly is Maneka Gandhi judgment. So this judgment is about the Article 21 of the Indian Constitution. Okay, so post Maneka Gandhi judgment, the right to life has witnessed developments, new dimensions were started, added to the Article 21 of the Indian Constitution. Now we need to discuss about few cases which the Supreme Court has interpreted as part of Article 21. So firstly, Francis Corley Mulhin versus Administrator, Union Territory of Delhi. So where the former Justice Bhagwati, he observed that the right to life that is being enshrined in Article 21 of the Indian Constitution, it should not be restricted to mere animal existence of human beings. So it is not just about the mere animal existence. So rather, the Supreme Court in Chameli Singh versus State of UP. So this was another case from the earlier mentioned case. The Chameli Singh versus State of UP case, the Supreme Court held that there's a need for decent and a civilized life, and that should include right to food, right to water, and a decent environment. Now you can observe how Supreme Court has been trying to constitutionalize the environmental issues. So firstly, in earlier mentioned case, so we are talking, the Supreme Court has talked about the right to life doesn't mean that it is just a mere animal existence. So in the second case, that is Chameli Singh versus State of UP case, the same Supreme Court has held that there is a need for decent and civilized life of every citizen of this country. So that includes sustainable environment. Okay, so free from the environmental pollution. So in this process, the boundaries of the fundamental right to life and personal liberty that were being guaranteed under Article 21 were further expanded to include the environmental protection. Okay, so whatever the boundaries that were in the Article 21 of the Indian Constitution or that were guaranteed by the Article 21 were further widened. Okay, so that includes the environmental protection angle as well. Now secondly, we need to talk about another major judgment, that is MC Mehta versus Union of India judgment. So in this judgment, the Supreme Court has again held that the right to live in a pollution-free environment as a fundamental right, and that should be part of Article 21 of the Indian Constitution. Okay, so every individual or every citizen have the right to live in a pollution-free environment. For example, nowadays, if you look at major metropolitan cities in our country, they are significantly impacted by the heavy pollution. Okay, so extreme levels of air pollution. Now in this context, right to live in a pollution free environment has included in Article 21, and it has further widened. Now the Supreme Court has also interpreted the Constitution, interpreted the fundamental rights to include the precautionary principle as well. Okay, so to include the precautionary principle as well. Now what does this precautionary principle actually means? So precautionary principle is that the environmental degradation or environmental pollution is being recognized or identified. So therefore, in order to control pollution, in order to control the environmental degradation, there is a need for adequate precautionary measures that should be taken. So this is what the precautionary principle actually talks about. So in this context, Indian judiciary, that is India's Supreme Court, also talks about the precautionary principle. Okay, precautionary principle. So this is particularly evident from the fact that in Vellore Citizens Welfare Forum versus Union of India case, so that was in the year 1996, the Supreme Court has opined that sustainable development should be the need of the hour. Now we have Sustainable Development Agenda 2030. Okay, so Supreme Court in 1996 itself has recognized the sustainable development, the need for the sustainable development, particularly in the context of environmental pollution and environmental degradation. Now in this particular case, that is Vellore Citizens Welfare Forum versus Union of India case, the Supreme Court has also emphasized that there should be a balance between economic growth. There should be a balance between economic growth as well as protection of environment. Now this is a major conflict in contemporary or modern societies, whether we should prefer the environmental protection or we should favor the development. For example, if you look at the developing countries and least developed countries, so if they focus on environmental protection, a sizable share of population in these countries will live in poverty. Okay, so since they do not have the adequate living standards, that could be detrimental for the country and its growth in the long-term period. So however, in Vellore Citizens Welfare Forum versus Union of India case, the Supreme Court has particularly emphasized on the balance between economic growth and protection of environment. So the court has also opined that the precautionary principles was evolved because of lack of scientific certainty only, and the principle involves anticipating the harm the environment may suffer. Okay, so the precautionary principle has actually devised keeping in mind that if we do not take adequate or necessary measures to control environmental pollution, to prevent degradation of environment and essential resources, okay, so that adequate precautionary measures could be taken. Now after that, there is also another principle called polluter pays principle. Now if you regularly following newspapers, or even if you are revising your syllabus in environment, you also come across the word, that is an important concept, that is polluter pays principle. Okay, so the polluter pays principle means there are certain industries, so certain industries or certain activities in a particular country or a particular territory, they are detrimental to the environment. They are polluting the environment. They are contaminating the natural resources. Contamination of natural resources. So because of this reason, the onus of taking responsibility for such pollution is actually lies on the polluter of that particular industry. So if we apply this polluter pays principle, we need to talk about the private iron and steel industries or aluminium industries. So they emit a lot of greenhouse gases along with a lot of pollutants into the environment. So they even pollute and contaminate the surface water resources. So in this context, the onus of the pollution lies on this particular iron and steel company. So this is what in brief is called as a polluter pays principle. So in oleum gas leak case, so that is otherwise called as MC Mehta versus Union of India case. Why MC Mehta case is significant? Because in this particular case, the Supreme Court has widened Article 21 of the Indian Constitution. The Supreme Court says that the right to life also includes the right to live in a pollution-free environment. Pollution-free environment. So this is what the Supreme Court has emphasized in MC Mehta versus Union of India case. Okay. Now, in this particular case, the Supreme Court held that if any industry or any enterprise, so that is being engaged in the releasing of hazardous gases or dangerous, gases, or they have a potential threat to the health of the workers who are working in that particular industry or people surrounding the industry. So if there is any substantial harm to their health, the well-being, then the responsibility of this or the onus of this pollution lies on the industry. Okay, so this is what the Supreme Court has held in MC Mehta versus Union of India case. So you can see here the enterprise is absolutely liable to compensate for such harm and irrespective of all reasonable care taken on his account. So this principle is called as polluter pays principle, and this is also very important in constitutionalization of environmental problems in India. So the fourth thing we need to discuss is about the principle of public trust. Okay, so the principle of public trust is also one of the most important concept in the constitutionalization of environmental problems. For example, in MC Mehta versus Kamalnath case in the 1997, the Supreme Court has given an important verdict about river Bias. Okay, so what was the nature of the verdict? So in this particular case, river Bias waters were diverted to a private span motel. Okay, so this is a kind of a hotel. Okay, a politician has diverted the waters of river Bias to flood the span motels. So that was in Kullu Manali. Okay, now in this context, in MC Mehta versus Kamalnath case, the Supreme Court has intervened and the Supreme Court has used the principle of public trust. So the Supreme Court has intervened and the Supreme Court used the principle of public trust doctrine. So in this particular case, and Supreme Court has also restored the environment to its original condition. Okay, so this is how the Supreme Court intervention has led to the controlling of or prevention of environmental degradation. Secondly, we need to talk about the intergenerational equity principle as well. Now, what is intergenerational equity principle? So this is also close to the sustainable development. Now, what exactly is the sustainable development? Sustainable development is development that meets the needs of the current generation without the future generations. They don't face any problems while using the resources. So this is the sustainable development, and intergenerational equity principle is also very close to the principle of sustainable development. However, the Supreme Court in state of Himachal Pradesh versus Ganesh Wood Products, that took place in the year 1995. So in this particular case, the Supreme Court held that maintenance and preservation of forests, natural resources for future generation is actually the duty on the part of the government as well as the citizens. So management of these natural resources is the responsibility of the government and citizens. So therefore, it led to the concepts like sustainable development of natural resources and also the intergenerational equity principle. Okay, so just mention these cases in most of these points. And after that, we need to talk about the absolute liability principle. So what does the absolute liability principle means? So we need to talk about the Bhopal gas leak case. Now in Bhopal gas leak, that is methyl isocyanate. So in Bhopal gas leak, what happened was several people lost their lives, and even most of the people in that particular region have been suffering with fatal diseases because of the release of methyl isocyanate. So even in Vishakhapatnam recently we have observed the release of styrene gas from the LG polymers. So in this context, the liability should be on the culprit. So in case of any harm or any hazard that took place because of particular industry, the liability should be on the polluter or the actual company. So this is talking about the absolute liability principle. So in this way, over a period of time, the Supreme Court has started to constitutionalize environmental problems and further widening Article 21 of the Indian Constitution so that the citizens can live a decent, dignified and in a pollution-free environment. And this is also important to ensure that the international law, human rights which are being linked to the environment, and also domestic environmental laws were implemented in letter and spirit. And that is very important, particularly in the context of development versus environmental protection debate. Development versus environmental protection debate. So this is how you can conclude this answer. So the next question, it is about the fundamental rights. See, in prelims and mains examination, fundamental rights, fundamental duties, and even the directive principles are very important. So this question is about Article 90. Okay, so right to movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute. So what does it mean when we say these rights are not absolute rights? So these are not absolute rights. Okay, so there are these rights are subjected to reasonable restrictions. They should be reasonable restrictions on these rights. So they are not absolute in the nature. So since it is just a 140 word answer, we need to write this in a brief manner. So firstly, the right to movement. So right to movement and residence throughout the territory of India is actually recognized as one of the fundamental rights that are available to all the citizens of this country. Okay, now so we have the fundamental rights from Article 13 to Article 32. Okay, so among these fundamental rights, Article 19 talks about right to freedom. Okay, so we know that Article 19 talks about right to freedom. So however, Article 19(1) subclause D talks about the right to movement, right to freely move throughout the territory of India. Okay, so there's another provision, that is Article 19 clause 1 subclause E. So it talks about right to residence. Okay, so in this context, Article 19 clause 1 and subclause D of the Indian Constitution, so it talks about the citizens can move freely throughout the territory of our country. Okay, so however, if you consider the applicability of this Article 19(1) subclause D, so it is not available to the foreigners. However, it is available only to the citizens of India and also the shareholders in Indian companies. Okay, so in this context, they are not absolute. Absolute means they're available to citizens and foreigners also, so they can move anywhere they want. So there are no restrictions on the rights of these individuals. So that could be detrimental to public health, morality, national security. So in this context, it is very important to have certain restrictions on these fundamental rights. So these Article 19 Clause 1 Subclause D is not available to the foreigners and other individuals, the alien individuals. Okay, so however, this Article 19(1) Subclause D talks about freedom of movement in 2 dimensions. So what are those dimensions? Internal dimension and external dimension. Now please understand, Article 1 Subclause D only talks about the internal movement. It is not concerned with the external movement. So a right to move within the country only is being dealt by Article 19 Clause 1 and Subclause D. So however, restrictions on the right to move within the country can be imposed. Okay, so it can be imposed on 2 grounds. So what are those 2 grounds? So firstly, the first ground is the public interest. The public interest. And the second ground on which the restriction can be imposed on the right to move within the or throughout the country is about the scheduled caste and scheduled tribes population. Okay, so there are certain restrictions when you are settling in these areas or buying land from the scheduled tribal or tribal areas. Okay, so this is specifically talked about in Article 19 Clause 5. Right. So there's another article, that is Article 19 Clause E. So this article actually provides for the right to reside and settle in any part of the territory of India. So any citizen can reside and settle in any part of the territory of India. So however, Article 19(1) Subclause D, similar to this very same fundamental right, Article 19(1) Subclause E also have certain reasonable restrictions. Okay, so reasonable restrictions means these rights are not absolute. They are subjected to restrictions. So for example, when those restrictions are being applicable, so for protecting the interests of the scheduled tribes in India, so because I have already told you that, so you cannot purchase the land of tribal communities, and you can also not eligible, or you are not allowed to have your own house in these tribal areas. Okay, so this is a first restriction. And in fact, with respect to the tribals, various provisions were mentioned in the 5th and 6th schedule of the Indian Constitution. Okay, so I hope you know about the 5th and 6th schedules of the Indian Constitution. So they are very important schedules. Now 5th schedule deals with the administration and governance of tribal areas across the country, and 6th schedule particularly talks about Assam, Meghalaya, Tripura, Mizoram. Okay, so these 4 states. Okay, the 5th schedule and 6th schedule of the Constitution. So therefore, the 5th schedule and 6th schedule also prohibit the transfer of land in such areas, as well as it regulates the allotment of land within tribals and outsiders as well. However, in this context, we need to understand one particular case, that is a state of Uttar Pradesh and Kaushalya case. So in this particular case, the Supreme Court has held that there should be certain restrictions on the movement of prostitutes. Okay, so this is very important, please understand. So there's a restrictions on the movement of prostitutes. So why? Because their unregulated movement throughout the country would have serious implications for public health and in the interest of public morals. So therefore, because of this reason, Supreme Court in state of UP versus Kaushalya case has imposed restrictions on the movement of these prostitutes. So in conclusion, you can write that hence this right So right to movement throughout the territory of India and right to settle in any part of the territory of India, while enhancing the mobility of Indian citizens. So even though there are restrictions, it enhances the mobility of Indian citizens throughout the territory. Okay, so however, it is also subjected to certain restrictions, and hence facilitating the mobility of citizens and the restrictions on the other hand helps in maintaining the fine balance between freedoms and the rights of the people. So this is how you can conclude the answer in a positive manner. So the next question is about the 73rd constitutional amendments. So see, this is also one of the most important question that UPSC every year repeats, whether it is about the 73rd Constitutional Amendment Act or 74th Constitutional Amendment. So every year UPSC definitely repeat the 73rd Amendment. So in this context, prepare this topic well. So understand the basic tenets so you can write the best answer. Now the question has been asking that to what extent in your opinion the decentralization of power in India changed the governance landscape at the grassroots level. Now grassroots level is the third tier of governance. It can be called as third tier of the governance. So in this context, how the 73rd Constitutional Amendment Act led to the decentralization, and decentralization has further led to the changing governance at the grassroots level. Now firstly, understand the 73rd and 74th Constitutional Amendment Act. So the 73rd and 74th amendments to the Indian Constitution have recognized the third tier of the government. So not just recognize the third tier of the government, they also provided the constitutional status to the local bodies or the local governance institutions. So therefore, it has created a wider legal conditions or favorable legal conditions for local self-rule. Now, if you remember Article 40, so it particularly talks about the village level governance or local self-governance. Now the 73rd and 74th constitutional amendments were passed in the spirit of Article 40. Okay, so the Panchayat Raj and municipalities were created by this 73rd constitutional amendment. However, under Article 40 of the Indian Constitution, states shall take steps to organize village panchayats and endow them with powers and authority to function as units of self-government. So this is actually the basic tenet of Article 40. So this talks about establishment of local self-governance institutions. So in this context, the 73rd Amendment Act of 1992. So this act has added a new part. So the part is part 9 of the Constitution. Okay, so this has not just added the part 9 of the Constitution. However, this also added Schedule 11 to the Indian Constitution. That is 73rd Constitutional Amendment. However, the 74th Constitutional Amendment has added Schedule 12 to the Indian Constitution. So if you look at the provisions related to Panchayat Raj institutions in the Constitution, they are confined to Article 243 to Article 243O. Okay, so a new schedule, that is 11th schedule, also created in the Constitution through the 73rd Constitutional Amendment. So however, there are certain subjects, certain functional subjects that are under the purview of these local bodies or panchayats. So the 73rd Constitutional Amendment Act has provided for the 29 functional items with panchayats. Okay, so they are dealt by Article 243. So in fact, this particular Amendment Act has provided the constitutional status to the Panchayati Raj institutions, thereby providing a proper legal framework or legal basis. Now in this context, it has brought them under the purview of justiciable part of the Constitution. So therefore it is justiciable. So for example, if you look at directive principles of state policy, so they are not justiciable. Fundamental duties are not justiciable. However, fundamental rights are justiciable, and similarly the 73rd and 74th Constitutional Amendment Acts are also justiciable. Now in this context, so what are the major achievements because of the decentralization of power? So there are certain achievements. Firstly, the decentralization of decision making at the grassroots level had taken place, because now people have been actively participating in the decision making process or the governance process in the local level. So that has ushered in participatory governance at the local level. Secondly, women empowerment or women representation has also significantly increased, because 73rd Constitutional Amendment Act has provided 33% of reservation for women. So therefore, women representation has significantly increased at the grassroots level, and that further led to the political empowerment of women. Okay, and even women representation has further diversified Indian democracy. And the successful implementation of Swachh Bharat Abhiyan program can also be linked to the the success of the Panchayat Raj institution, because in the year 2019, so India became an open defecation free country. So this is particularly because of the wonderful work that is being done by these local bodies. So very often these panchayats or the local bodies take the driver's seat when it comes to organizing the literacy campaigns. So one example is Arati Devi. She is a sarpanch of Ganjam district in Odisha. So she is credited with the starting a literacy campaign in this district or in particular panchayat. So this is particularly focused on women and reviving the traditional folk art in the Ganjam district. Secondly, we need to talk about the self-help groups. Okay, so in panchayat level or local level, self-help groups have a very crucial role when it comes to education, healthcare, financial empowerment of women, making them financially independent, self-sustainable. So everything in this context, self-help groups have a huge role. So Meena Behan, a sarpanch from the Gujarat, a village in Gujarat, has worked to inculcate leadership skills among the self-help group women, so that they can start their micro units. Okay, so they can start their handicraft making and food processing, etc. So they can earn substantial income, and that helps them make financially independent. So however, there are some issues in the Panchayat Raj institutions. So they have halting the decentralization of powers in letter and spirit. So what are those issues which are actually halting the decentralization of power in letter and spirit? So firstly, inadequate finances is a major problem with respect to these panchayats. So because the financing powers are mostly wielded by the state governments, and they are reluctant to devolve these financial powers to these Panchayat Raj institution. So therefore, they have a very limited power when it comes to imposing cess and taxes. Secondly, there's an unscientific distribution of powers to these local bodies. Even several parallel bodies were also created along with these local bodies. So therefore, that has been leading to the diffusion of responsibilities and unscientific distribution of existing functions among these institutions. Okay, so panchayat and panchayat samitis functions overlap, leading to confusion, duplication of efforts among these institutions. Now after that, we need to talk about the lack of cooperation. Okay, so lack of cooperation or coordination. For example, government officials do not coordinate with the local political representatives. Now that further led to the policy paralysis at the local level, and even citizens losing trust over the local self-governance institutions. And similarly, there were no real functions with these local bodies. For example, the real functions like education, healthcare, sanitation, water, so they remain concentrated with the state governments. So substantial amount of powers, functions, funds are remain concentrated. Major decisions are taken by the state government. So that also a major issue in the effective functioning of these local self-governance institutions. However, while writing conclusion for this answer, for local bodies and panchayats to play a much bigger role in human capital interventions, there is a need for adequate fiscal resources through the State Finance Commission that is being created by the 73rd Constitutional Amendment. So there should be adequate devolution of funds and finances to these local self-governance institutions along with functions and functionaries. So that is the essence of making these institutions function as effectively as possible. However, the 6th schedule and 5th schedule have provided a kind of autonomy for few tribal areas, and such autonomy should be extended to these panchayats. So therefore, we can make them function in an effective manner. Now, the next question is about the chairman of the Rajya Sabha. Now, understand, India's vice president is also chairs the proceedings of the Rajya Sabha, and he is called as chairman of Rajya Sabha. He is called as chairman of Rajya Sabha. So, however, vice president is not the member of the upper house, then also he is the chairman of the Rajya Sabha. Okay, so in this context, the question has been asking that discuss the role of the vice president of India as the chairman of Rajya Sabha. Now, firstly, in the introduction, you briefly write about the chairman of Rajya Sabha. So, vice president of India is actually the ex officio chairman of the Rajya Sabha, or otherwise called as upper house. Now, the vice president as the chairman of the Rajya Sabha is the unchallenged guardian of and the eminence dignity of the house. So he has the major responsibility when it comes to ensuring dignity in the house, maintaining decorum, so smooth functioning of the proceedings of the Rajya Sabha. The greater responsibility or the onus lies with the vice president or the chairman of the Rajya Sabha, because the vice president himself chairs the proceedings of Rajya Sabha. So, however, we need to talk about the major constitutional provisions. They deal with the vice president or chairman of Rajya Sabha. So, firstly, Article 64. So, what Article 64 talks about? So, Article 64 says that vice president shall be the ex officio chairman of the Council of States or the upper house, and he should not hold any other office of profit. So vice president becomes chairman of Rajya Sabha and he should not hold no office of profit. So this is what Article 64 talks about. However, Article 89 of the Indian Constitutions provides for certain provisions related to the chairman, who is the vice president of India, and also the deputy chairman of Rajya Sabha. So these are the constitutional provisions. Article 64 and Article 89 are related to the chairman of Rajya Sabha. Now, so what are the powers and functions, the role of the vice president as the chairman of Rajya Sabha? So as the chairman of the Rajya Sabha, vice president is empowered to adjourn the house or suspend its sitting whenever there is an absence of quorum. And what is a quorum? So if there is 10% of the attendance of the total members in a particular house, then the chairman can go ahead with conducting the session. So however, if there is no quorum of 10% of the members, the chairman may not conduct the session. He may adjourn the existing sitting, not the session but existing sitting. However, the 10th schedule, so we all know about the 10th schedule, and 10th schedule talks about the anti-defection law. So when it comes to taking decisions with respect to anti-defection law, the chairman has to decide. Okay, so chairman have the powers to decide the question of disqualification under the 10th schedule of the Constitution. Okay, so whenever it deals with the members of Rajya Sabha, right? So chairman's consent is also needed whenever a member of Rajya Sabha is raising any question of breach of privileges in the house. Okay, so the privileges were also mentioned in Article 105 of the Indian Constitution. So whenever it comes to the breach of privileges, the consent of the vice president or the chairman is required. Now the parliamentary committees, so regardless of whether they are set up by the chairman or by the house itself, but they essentially work under the supervision of Rajya Sabha chairman. Okay, so this is the major roles and responsibilities of the chairman of Rajya Sabha. Now, apart from above discussed roles and responsibilities, chairman of Rajya Sabha also nominates few members to different standing committees and departmentally related standing committees. And apart from nominating these members, the chairman of Rajya Sabha also becomes the chairman of the Business Advisory Committee, Rules Committee, and the General Purposes Committee. Okay, so he also becomes the chairman of these committees. And apart from that, when it comes to the proceedings of the Rajya Sabha, he has the ultimate say. Okay, so he has the ultimate say whenever it comes to the interpretation of the Constitution regarding the procedure and provisions of the House. Okay, so it is the duty of the chairman to interpret the Constitution and rules so far as matters in relating to the House are concerned. And no one can enter into any argument or controversy with the chairman over any such interpretation or any such decision which is being made. So when we talk about the removal of chairperson, so he could be removed only by the chairman. So he can only be removed as the chairman of Rajya Sabha when he is removed from the office of Vice President of India. Now when he is being removed from the office as the Vice President, he will also be removed as the chairman of Rajya Sabha. So while resolution for his removal is in effect, resolution for the removal of Vice President is in effect, he cannot preside over the House as a chairman, although he can take part in the proceedings of the House. Okay, so I mean, even if when we consider the removal of the Vice President, firstly a resolution should be passed in the House, upper house, Rajya Sabha. So after passing this resolution in the upper house, this should be agreed upon by the lower house to remove the Vice President. Okay, so once he is being removed by the removed as the Vice President, he'll also be removed as the chairman of Rajya Sabha. So however, the role of chairman in the proceedings of the Rajya Sabha are very crucial in order to further strengthen parliamentary debates, discussions, further strengthening the quality of debates, the parliamentary committees functioning, and ultimately strengthening the democratic principles and democratic structure in India. Okay, so this is how you can conclude this answer. So that's all for today, and please subscribe to our YouTube channel, and if you like the video, please hit the like button, and thank you.